Good evening. Sometimes I am too generous, too lenient with people, I think. This is Too Dumb for Lawyer. This is what I was responding to this morning. This right here. A traffic stop is a custodial arrest. Obviously, he provides nothing to back this. He just makes the assertion and leaves me to do the grunt work. Well, I stated that a traffic stop is not necessarily even an arrest, let alone a custodial arrest. Some states make citations in lieu of arrests into constructive arrests or into arrests, non-custodial arrests. They call them different things. Texas doesn't allow people to get arrested for a speeding ticket, so they have to throw quotes around arrest in their case law. Well, you're kind of technically arrested, sort of, because you were issued a summons, and the ticket is essentially or you weren't issued a summons. The ticket is essentially a complaint, and you were stopped by the cop. So it's enough like an arrest that we'll treat it like an arrest. But it's not custodial. Custodial means you're taken into custody. And sometimes, if you're stopped in traffic, like I said in the morning video, they will take you into custody. If they have probable cause to make an arrest, they may take you into custody and actually arrest you and actually bring you into the station and process you and put you in a holding cell until you can go in front of the magistrate or judge or whatever they do in your state. But to make the blanket assertion a traffic stop is a custodial arrest seems really stupid. So I naturally assumed that he wasn't that stupid, and boy was I wrong. First thing I want to note is that I wasn't strawmanning him. This is the thumbnail where I actually took a picture of his statement. That's the thumbnail. That's what I was responding to. But I didn't think he'd be so stupid to actually go on about it being a custodial arrest. I thought that was maybe a slip of the tongue. Maybe he didn't realize what he was saying. But yet, he is sure that all stops, not just traffic stops, all stops for mere RAS, which is reasonable suspicion for those of us who aren't sovereign citizens or in this fucking retarded community outside of the Fifth Circuit. The Fifth Circuit uses RAS, but most sane people don't. You could just say reasonable suspicion. He says all stops, traffic or not, for mere reasonable suspicion or custodial arrest. Again, no citation. I can't even hardly respond to this. This is Terry v. Ohio. It's quite plain the Fourth Amendment governs seizures of the person which do not eventuate in a trip to the station house and prosecution for a crime. Arrests in traditional terminology. Terry v. Ohio differentiated between stops, Terry stops, and arrests. They have two separate levels of proof, I guess, required. Reasonable suspicion for a stop. Probable cause for an arrest. The Terry frisk is based on the reasonable suspicion. You may be armed. You may be dangerous. You may pose a safety risk to the officer. The officer can do a pat down, outer layers of clothing for weapons. That's it. He's looking for weapons. Now, if he finds a non-weapon in his pat down, maybe you have a marijuana container that is shaped exactly like a pistol. You might think that's a pistol. Pull it out. It's a marijuana container. Now he has probable cause, right? Because there's marijuana. Jazz cabbage, devil's lettuce. But the Terry frisk is based on reasonable suspicion. Outside of the clothing, looking for weapons. If you are arrested, which is a legal term, if you are arrested, then the officer can do a full search of you, an inventory search. He could take everything out of your pockets. He can go through your wallet. He can look inside everything because he's bringing all that stuff into jail. Now, obviously, he can't go through your cell phone because your cell phone doesn't have a firearm in it or anything that it has information in it that he doesn't have a good enough reason for. And the courts have held that he needs probable cause to get into the cell phone. Probable cause that the cell phone has information, blah, blah, blah. But he can go through your wallet. That's for darn sure. And when you get to jail, they can strip search you. They can do all that other fun stuff. So they are quantitatively different in what the police can do to you, with you, between a reasonable suspicion stop and a probable cause arrest. They're different. And this is US v. Sharp. I've talked about this case before. Savage was driving a truck that had a camper shell on it, and it had quilted blankets covering the windows. And it was heavily loaded, unlike every other camper ever. And it was in a known marijuana trafficking corridor. He was carpooling. He's basically caravanning, with Sharp. Sharp was driving a vehicle behind him, and they were driving too fast. DEA agent gets behind him, pulls over Sharp. Sharp doesn't have any marijuana on him. He's just in the I don't remember which is Smokey and which is the Bandit, but he's in the Trans Am. There you go. He's in the Trans Am. Savage is driving up ahead in the semi loaded with a contraband. Obviously, it wasn't a semi, but whatever. You get the analogy. So the DEA agent has pulled over Sharp. He's radioed ahead to other agencies to pull over Savage. Other agencies pull over Savage. When they pull him over, the DEA agent leaves Sharp in the care of some local law enforcement. Goes to Savage, opens up the camper on reasonable suspicion, pulls out a marijuana bale, reasonable suspicion, smells, or maybe it's probable cause at that point actually, because he can smell the marijuanas. Opens up the marijuana bale, bada boom, bada bing, Savage is popped. Sharp was held on reasonable suspicion. Sharp was held for a long period of time. It's a detention. You see how they keep saying detention? Detention. The only issue in this case then is whether it was reasonable under the circumstances facing Agent Cook and Officer Thrasher to detain, not arrest, detain Savage, whose vehicle contained the challenge evidence, for approximately 20 minutes. We conclude that the detention of Savage clearly meets the Fourth Amendment's standard of reasonableness. It's a detention. It's not an arrest. Kansas has, this is their code of criminal procedure method of arrest. An arrest is made by actual, not constructive, actual restraint of the person. The person has to be actually restrained. Handcuffs, put in the back of a patrol car. Now, obviously, there's Supreme Court jurisprudence that suggests that there is such a thing as constructive arrest. If you're brought to a police station for interrogation, questioning, and they close the door behind him and you're in the room and you're not free to leave, it might be arrest. Again, it's a very fact-based determination, whether you are under arrest, whether you're there on your own free will. It's Florida v. Royer, if anybody wants to look that up. Florida v. Royer, he was flying with an assumed name, trafficking drugs. The cop stopped him, wanted to see his ID, wondering why he was flying under an assumed name. Then they asked him to come back. They had his ID in their hands. They had his ticket in their hands. They asked him to come to a interrogation room. He didn't really have a choice. He was under a constructive arrest at that point. I mean, he just didn't he wasn't free to leave. Obviously, he wasn't free to leave. They had his shit. They had his ID. They had his ticket. He wasn't free to leave. Florida v. Royer. Look it up. But an arrest is made by actual restraint of the person arrested or by his submission to custody. Not to be stopped, but to custody. This is the Vehicle Code, Chapter 8, Article 21, Section 4. When person to be taken before judge of district court, because fuck grammar, we're in Kansas, arrest at discretion of officer, when traffic citation only in certain cases, the worst sentence ever. When a person is stopped by a law enforcement officer for any violation of any provision of the Uniform Act regulating traffic on highways not amounting to a felony, the person shall be taken into custody. When they're stopped, they shall be taken into custody. When they're stopped, they shall be taken into custody and taken without unnecessary delay before a judge of the district court as specified in subsection D. When they're stopped, so they're differentiating even in the statute between being stopped and taken into custody. Into custody meaning custodial arrest. When any person is stopped by a law enforcement officer for any violation of any provision of the Uniform Act regulating traffic on highways, which violation is a misdemeanor and is not required to be taken before a judge of the district court is required in subsection A, the person, in the discretion of the law enforcement officer, may be taken into custody. So they're stopped. They may be taken into custody and taken without unnecessary delay before a judge of the district court as specified in subsection D. Again, they're differentiating between being stopped and being taken into custody because there's a difference. I think I've proven my point. There is a difference. And this moron who claims to be a non-attorney lawyer who took a traffic ticket all the way to the SCOTUS. Wow. He took it all the way to SCOTUS. Of course, he won't say who he is, and he won't give any indication of what case it is. Fourth Amendment issue. Yeah. You probably thought that a traffic stop is a custodial arrest. You idiot. Not granted certiorari. Well, maybe they think you're a fucking retard. And here's the fun thing. Depending on the court you're in, and depending on state law or federal, it doesn't. I don't know what court he's in. Obviously, he won't give any information because he's just going to make claims without anything to back anything up ever. There are rights to appeal. That you have a right to appeal various things. So exhausting your rights to appeal doesn't mean anything. It doesn't mean you had a good case. I'm going to guess that since this asshat still, after taking a Fourth Amendment issue all the way up through, I don't know what fucking court, because he won't say. Was it the state Supreme Court? Probably not. Was it a federal circuit court? More likely. But just because he took it up as far as he could go before his next step being SCOTUS or nothing, it means nothing. It just means he lost. The only thing it means is that he lost. Because if he won his traffic ticket case at the state level, it wouldn't have gone anywhere. If he won his traffic ticket case at the federal district court level, it would have been done. If he won his federal his federal court of appeal case, it would have been done. But he didn't. He didn't win shit. If he won, he would have said something. He didn't win shit. So anyway, that's the kind of non-attorney lawyer advice you can get on YouTube. Enjoy it. The guy doesn't recognize Terry v. Ohio. Whatever. Thanks for watching. Have a great day.